Good morning. Let me just jump in again this morning. The title for today is It's Not Over Till It's Over. I'll leave that out. I was going to quote Casey Stengel, or was it Yogi Berra? Anyway, it doesn't matter. Today I will talk about the non-jury trial related to the charges against me of driving without a license and resisting arrest without violence. It is my hope that those who watch and listen notice the manner in which Spirit leads me to address injustice, specifically with a lot of grace and forgiveness. This needs to become the conscious state of humanity and applied as liberally as possible in righting the many wrongs in our world that we are more aware of than ever before. Bear in mind that most of the people we are dealing with in the system are just doing their job. Most are not evil, and even those that may appear evil still have a divine spark within them, or they would simply cease to exist. I think I'm going to I've been debating whether I'm going to read this whole thing or not, but yesterday, late afternoon and into the evening, and then again this morning, I've tweaked it a little bit further. A document that I will be submitting to the court today in regard to the non-jury trial. And rather than me trying to explain the process to you, I think it might be easier just to simply read you the few pages that I've written and let you hear for yourself the manner in which I've addressed the issue with the court and with the state of Florida, who, by the way, is the plaintiff in the matter. The title of the document is called Affidavit, Conditional Acceptance of Order Offer. Defendant Ronald T. Van Dyke responds to the non-jury trial conducted in the afternoon of Tuesday, February 12, 2013, in the following manner, affirming the following to be the truth as he knows and understands it to be. Number 1. Defendant understands the following maxims of law as applicable in this matter. A. Truth is expressed in the form of an affidavit or sworn statement. B. An unrebutted affidavit stands as truth in commerce. C. An unrebutted affidavit becomes the judgment in commerce. D. He who does not deny admits. E. No one is believed in court but upon his oath. This document is to be construed by the court as an affidavit of truth. Number 2. Defendant was demanding a trial by jury throughout this matter, which is his guaranteed right under the law based upon the honorable constitutions of the United States and the state of Florida, a fact substantiated in documentation provided to the state and the court prior to the non-jury trial. 3. Defendant agreed to a non-jury trial, not expecting the state to produce any witnesses in this matter due to issues raised prior to the trial itself, believing that the case had been virtually settled because the state had failed to follow its own statutes and requirements of the law, both in the issuance of the alleged summons, which was not provided to the defendant by the state or the court for nearly 6 months after it was supposedly written, and in the execution of the alleged arrest in which the defendant's rights guaranteed under the constitutions aforementioned were grossly violated. Number 4. The defendant was half right in his expectations. The state did not produce any witnesses on the more serious violations of defendant's rights, namely the charge of resisting arrest without violence stemming from the unlawful arrest and illegal detainment of the defendant, which was in fact a crime committed by the state against the defendant, making the defendant an injured party in this matter. Defendant was shocked that none of the pretrial material was allowed unless represented at the trial itself. He was not prepared for this, having spent much time working on his lawsuit in federal court up to and including the morning of the trial without prior review of the previously submitted materials. Let all of those materials be represented here on the record and in full as originally submitted. The deputy, as the state's witness on the driving without a license charge, actually changed his story from the affidavit he had filed prior to the trial, which the defendant did not catch until afterward. Again, this was due to the lack of preparation by defendant for reasons already stated. Number 7. Specifically, the plaintiff's witness did not state in his original affidavit the purpose or reason for his alertness in relation to Mr. Van Dyke's appearance at the alleged foreclosure auction of his home, did not reveal how he had been alerted by unnamed parties in that affidavit, and did not state that he had followed Mr. Van Dyke through the Brevard County Service Complex building, watching to make sure that he did not cause a disturbance. This reveals a serious discrepancy that might indicate tampering with or coaching the witness based on defendant's concerns previously expressed in open court. The incongruence between the deputy's original statement and on the record and his testimony at the non-jury trial leads the defendant to rebut his testimony on and for the record in each instance where there is no agreement on the basic facts between the deputy's affidavit and his testimony. Prior to the trial, which the defendant thought would be a way to a quick resolution of the case, the court failed to respond to some of his motions previously submitted, thereby failing to provide due process of law prior to the non-jury trial. The defendant did not press the court on this matter because of his desire to find resolution as quickly and easily as possible. 9. In the non-jury trial, the court found the defendant guilty of driving without a license, despite the fact that he was doing so based on solid law, citing right-to-travel cases which were not at his fingertips at the trial, though they had been provided to the state and court prior to the trial. In fact, defendant, as stated above, hereby re-enters all paperwork previously submitted to the state and the court as relevant in this matter. This is repeated to assure defendant that no matter raised before said trial will be ignored. Number 10. In rendering the judgment and issuing the order for the defendant to pay court costs of $231 by August 12, 2013, the judge specifically stated that defendant had 30 days to appeal his decision. This is an appeal of that decision. Number 11. Furthermore, defendant perceived the judgment and court order as a contractual offer, yet the court did not even ask for the defendant's signature on the order itself, making it non-binding, albeit the state and the court may consider it a type of adhesion contract that is assumed valid unless rebutted or denied, which it now is. 12. Therefore, the defendant chooses to cancel the unilateral contract within the 72-hour period provided in commercial law for cancellation of contracts. All law is commercial law. All government is by consent of the governed. All law is contract. Contracts are agreements between parties. Defendant offers the following contract. I left out a letter, and I'm glad I'm reading it. Whoops, got to take all caps off. Counter offer. Number 13. However, defendant will, in good faith and extending grace to the state and the court and its actors, as the magistrate, judge, and federal lawsuit calls them, conditionally accept the court's order offer as a means to a just and quick resolution of the cases without further complication, provided all parties also agree to the following condition. Since it failed to prosecute in the matter, let the court also find the state guilty of false arrest and other violations of law and statute arising from the charge of resisting arrest without violence, withhold adjudication, and require the state to pay defendant minimum damages of $231. It is to be understood that this is a huge bargain and gift the defendant is offering in order that this matter be firmly resolved without further recourse from any party in the matter in the matter. In other words, dismissed without prejudice. This will cancel out and zero all matters related to these cases with no further action required of or allowed by any party. State must respond within 3 business days from this filing on February 15th, 2013, or by Wednesday, February 20th, 2013. Any response is to be in writing and provided to both the defendant and the court. Failure to respond is tacit approval and agreement. Silence is acquiescence. I affix my signature and official seal to all of the above affirmations without prejudice to any of those rights pursuant to UCC 1-207 and UCC 1-103.6 with explicit reservation of all my unalienable rights guaranteed by the United States Bill of Rights and the Florida Declaration of Rights as originally set forth in 1791 and 1838 respectively. Wherefore, Ronald T. Van Dyke moves this court to enter an order accepting the terms of this contract that, in effect, ends the case with no further payment or penalty required of the parties involved. Defendant also moves the court to remove or seal all records relating to this case from the defendant's record. Let this be in writing with signed copies provided to the parties involved. Witness my hand and seal, Ronald Van Dyke, defendant. So there you have it. That is how I responded to the court, and I noticed a couple of things that I might still need to further tweak as I read it for all of you. And it helps to read it out loud, by the way, because sometimes when I don't read it out loud, I miss things that I see when I'm reading it out loud. Anyway, I will make minor adjustments to that and submit that to the court and to the state attorney's office later this morning, prior, within the 72-hour period of the court hearing, so that I can cancel a contract. And I want you to understand that everything that the state or the government or any party does is an offer. Even a judge's order is an offer. It's all contract. You need to understand that. And whenever anybody submits to you a bill, it is not a valid bill unless they can also produce the contract that obligates you to pay it. Now, if it's a service rendered that you're receiving the service. So by receiving the service or the product, you are in fact validating the contract. But many, many times, especially the government agencies, present bills to people where there is no contract. And you have the right, and if you use that right, you can stop the need to pay that bill or that fine or whatever it is, because they have to produce a contract. All law is contract law or commercial law. All law is. The UCC is the bedrock of the way all monetary transactions are conducted in the entire world. And when you realize that, you will be able to gain remedy, even if you might get some resistance to the remedies. The remedy is lawful. That's what the One People's Public Trust has done. It's produced a lawful remedy to the situation of crimes against humanity. But let me go back to what I said in my opening blurb, and that is we need to understand that the human beings involved in all of this matrix system, most of them are doing so ignorantly. They're not aware of what they're doing. They haven't given it not even a single thought. They're just simply doing their job, and they're living their lives by rote. Show them grace. It's not about trying to punish anybody. It's not about trying to, so many people that are lacking in money I've had people tell me, go after them, Ron, take them for all they're worth. Even in the federal lawsuit. Yeah, it's a multi-million-dollar lawsuit. But for me, it's not about money. It's about justice. It's about being left alone. It's about reconciling the wrongs that have been done. And this is my goal. It's not about making myself rich because I am rich. Even if I don't have a huge bank account, which I certainly don't, I am rich because I know who I am. And it's not about money. It's about justice. It's about truth. It's about compassion. It's about love. It's about grace. Justice without mercy is tyranny. And it's not just. It's tyranny. It's still rule by force. Justice with mercy is the way spirit works. And this is something that, as we rise in consciousness, we must take to heart and consider important and validate this as essential in the creation of a peaceful world, a world where there is a win-win for everybody. I gave the court and the judge a way out so that they can save face and I can save face. They don't have to pay anything. I don't have to pay anything. The two charges just simply cancel each other out and it's erased. That's the offer that I've made them. Do you think they will accept it? I don't know what their response will be. We'll see. You never know until you do it. But be willing to challenge, especially the state, on things that they have no contract that you've agreed to. And if you haven't agreed to it, contest it. But do it nicely. Again, it's not about making the other person wrong. It's about awakening people to the higher truth and to find peace. To find peace in all things. Live peaceably with all men and women as much as possible, because this is the cooperational wave of the new paradigm. I guess that's it for today. Thank you for letting me share and for listening and for sending me love, and thank you for everything. I really appreciate you who listen. God bless you. Namaste.